My Lords, my Lady, can I start by briefly addressing the point that my Lord Justice Nugee raised with me before the short adjournment, and address why we're accepting that the supply of software is the supply of goods for the purposes of the Trade Secret Directive, particularly Article 4.5. What we say is software is as much a thing that can be produced in industry and dealt with in commerce, taking advantage of trade secrets as any other physical product. So it would be strange indeed if the Trade Secrets Directive did not encompass that in Article 4.5. The purpose of that provision is to make unlawful the dealing in things that have been enabled by a misuse if the requirements of the knowledge identified there are met. So one would naturally understand it to cover software. I was reminded over the short adjournment that in other EU law contexts, we see that goods definitely does encompass software. There was the case of software incubator under, I think, the Self-Employed Commercial Agents Directive. We'll make sure that my Lords and my Lady have copies of it after the hearing. But that was a case that concluded that it did, goods did include software, whether tangibly supplied or downloaded. And that point that software can be supplied to a user both ways on a physical carrier, say in the old days on a floppy disk or more recently a CD-ROM, or nowadays by a transfer between computers, whether over the internet or some other means. That distinction would mean that if you excluded software from Article 4.5, you'd exclude software however supplied, even in a tangible form, and we say that's not a sensible construction.
No. If there's physical goods, then it would apply. But you're right about software incubator, but of course, coming a little closer to home, in the copyright context, on the one hand, we've got UseSoft, which says that in the context of the software directive, computer software can, for certain purposes, be analogized to goods. And on the other hand, we've got Tom Cabinet saying that an e-book is not.
Indeed. So
it depends upon the terms of the specific legislation.
Context, and that's why the earlier points that I've made to my Lord and my Ladies, we say are particularly important on this. But the final point I make about this actually is that even if Article 4.5 doesn't cover software as goods, the consequence would not be that the supply is not subject to this Trade Secrets Directive at all. It will be that software developed in breach of confidence would, when exploited, be another misuse, not under paragraph 4.5, but probably under 4.4. But the consequence of that wouldn't be that the acts weren't capable of being a misuse, as I say, simply that the wrinkle I'm addressing on Article 4.5, as it refers back to Article 4.3, might go away. But it would still be a misuse, and moreover, the analysis in Selgard would still apply, because it's an act of unfair competition by supplying something in a market. And so we would say that the analysis would still apply equally. It's not to do with whether you call it goods. It's to do with the nature of the supply.
Well, but Article 4.4 isn't about supplying goods. It's about acquisition, use or disclosure of a trade secret.
Yes, and the submission that I'm making is that if it's not the supply of goods, it would be another misuse of the trade secret to sell software.
But in that case, Article 4.5 would be OTOs.
No, it wouldn't be OTS completely. It would just be that it didn't apply to software because goods in Article 4.5 doesn't cover software. That's the point that I'm addressing, I think. So all I'm saying to my Lords and my Ladies is that the consequence of this point, if software wasn't within goods, would simply to take it out of 4.5 and put it in 4.4, which might mean that the wrinkle that I'm addressing my Lords and my Lady on, because 4.5 refers back to 4.3, goes away, but it would still be a misuse.
Well, it depends. The focus in 4.4 would then be on the use, presumably.
And it still takes you back to paragraph 3 anyway.
It might do. You're right about that. It might do. So the point might not go away. But the most that could be said is that it goes away. It's still a misuse of a trade secret.
What is the misuse then?
What's the misuse?
Yes.
You're selling.
On the facts of this case.
You're selling an article whose existence and in part makeup is dependent upon the use of a trade secret.
But that takes you straight into the definition of infringing goods. It means goods, the design characteristics, functioning, production process or marketing of which significantly benefits from trade secrets unlawfully acquired, used or disclosed.
Which is why I'm accepting that the most likely way of looking at this is that software is goods and therefore Article 4.5 and infringing goods is what matters. All I'm saying to my lord and my lady is, if I lose on that, in fact, I'm just accepting it. If that's not right, it doesn't mean it's not within any of the other paragraphs. It just means by a footfall, I'm not goods, and therefore, if it's not that, it's still a misuse. I say probably under 4.4. But that's not my primary position. The only point I was trying to make is that it doesn't somehow mean that there's no misuse of trade secret just because I don't fall within 4.5 because software isn't goods.
Well, the question is, what is the relevant misuse? So there may be a misuse through accessing an environment, a platform, whatever you call it, in Latvia. But as you rightly accepted earlier in your submissions, that wouldn't assist you in terms of the applicable law analysis, let alone the appropriate forum analysis.
No, indeed, but you're still then selling the thing which is existence, and you'd have to have the knowledge of the misuse, because that's what paragraph 4 of Article 4 requires as well. So the only point I'm suggesting to my lords and my lady is that the analysis isn't actually crucially dependent upon me falling within 4.5, but I actually hadn't thought that I wasn't before my lord asked me. I say I am for the reasons that I've given, but I also say that the consequence, if I'm not, is simply that this issue might go away, probably not actually, but might, but the cell guard analysis doesn't go away. Now, can I go back to dealing with the issue and my lord's view on it? So I'm back in cell guard on page 403 of the bundle, and I'm dealing with the points that my lord briefly identified that cause you to incline to the view that you expressed that it's the Rome II law. And the first point you make is there's nothing in the Trade Secrets Directive that indicates itself is to include a choice of law rule, and that's the function of the regulation. And there you're referring to the Rome II regulation, as I understand it. And in fact, my lord could have gone further and referred to recital 37 of the Trade Secrets Directive that expressly disclaims dealing with these matters, including applicable law, something that says it doesn't deal with, and drawing attention to the fact that other EU instruments deal with that, which remain applicable in the field covered by the directive. You'll see that in Lydia Lundsted's book. She includes it as a footnote because I noticed that the actual directive is not in the bundle, but we will have the form of it in the footnote. My lord could have gone further and made that point. Now, the second point we make is the suggestion that it's EU law, i.e. autonomous law, can't be right because the directive specifically provides that national law may, up to a point, be more far-reaching, and it also has provisions recognising the effects of national law that you identify here. And the third point is that you're doubtful that it can be right to apply the law to the place of the acquisition for the reasons that you've been through. And as I alluded to before the short adjournment, my submission is that my lord is right in your view. And before we look at Lydia Lundsted's criticisms, can I pause and make some further points in support of the view that it's the same law, i.e. the Rome II, throughout? And the first is that a variation of the point that I identified earlier, namely that you end up with a weak trade secrets law being imposed in a place where there's a strong, and vice versa, would apply here also. This particular point has that same difficulty. It would also lead to further difficulties, perhaps absurdities in my submission. For example, can it really be intended that the place of the acquisition trumps the place where the market that will be affected by the unfair competition is, even in cases where it's a complete accident or perhaps contrived? Say the acquisition occurred in an airport lounge in some country with no trade secret protection, where person A met person B whilst waiting for a flight transfer. Can that really be what determines whether the goods are unlawful to be marketed in some country under the directive? We say not. We also say that the requirement for knowledge in Article 4.5 causes difficulties if you start looking beyond the law that Rome 2 provides, because you have to know or ought to have known the trade secret was used unlawfully within Para 3, which in the example we're considering means unlawfully acquired. And normally a provision like that doesn't require knowledge of the law, just facts and circumstances making the thing unlawful. But if we're judging by some other law, does the defendant have to know the other law? Or at least, does the defendant have to know the precise place the acquisition took place, because it's crucially relevant to the question of whether it's unlawful? It all becomes very impractical in my submission. Now, so those are further reasons that we would offer that support my Lord's view. Can I turn to the extract of Dr. Lundsted's book that my Lord drew our attention to? I think the other side have provided you copies.
Yes.
Good. The key bit, as my Lord's footnote in Dicey identified, is pages 86 onwards. And it's the section 4.8. And the first point the author makes is the directive doesn't contain rules on private international law. And that's why I said that the recital that's not in the bundle you can get from her footnote here. You see, footnote gives the text. And she goes on to say the legislators were clearly concerned with cross-border exploitation.
Sorry, can you just remind me of the page number?
Yeah, sorry,
It's 12. 12 of the little.
I'm sorry, I had a previous copy, and so if it's okay for my lords and my lady, I'm using the pagination in the book.
Yes.
So it's the small numbers at the top of the page.
Yep.
And I'm on 86.
Got it.
And she goes on to say legislators were concerned with the cross-border consequences. And she develops her point by explaining the question of unlawful use or disclosure within the key paragraphs of Article 4, that's 3, 4 and 5, is dependent upon the alleged infringer or tipper, which is the word she uses for a person who passes the information to the infringer, whether that person had previously, depends on whether that person had previously acted unlawfully. And she starts by very fairly drawing attention to the fact that one way of doing this is breach of a contractual obligation. So I'm now at the foot of 86. And over page 87, the author goes on to make the point that for contractual sub-paragraphs of 4.3, one will have to apply the law of the relevant contract. There are two paragraphs that apply to that, B and C. And this is used as a basis to suggest that one must also apply what is referred to as the law applicable to the preliminary question of unlawfulness if one is in Article 4.3. Now, what Dr. Lundsted then does is talk through an example involving a trade secret of a French company with a Swedish trade union representative who acquires the trade secret from an employee of that company habitually working in Sweden. And as I understand the situation she's referring to, the trade union representative owes a non-contractual duty of confidence under Swedish law. So the point she's making is it's not a contract obligation. And the question the author goes on to ask is, if the secret's disclosed, it happens to be Germany in her example, and used to make infringing goods that are then imported into France, how do you analyse the position as regards the importation claim? And she says French law would be applicable to the main question of the liability of the importer. So far, so good. And pausing here, my lords and my lady, that was the point that I tried to allude to earlier when I said that that actually is the governing law of the Act that you're concerned with. So even if her view that Swedish law determines the question of the antecedent unlawful act, she's agreeing that the main question, which must be the one that matters for our purposes, is the Rome II law. So that in a way is a short answer to the point insofar as it's relevant here. But we say that my lord's right in any event, that it's Rome II, even on the antecedent act. And that is the interesting academic question, the hard question, whether that antecedent act that has to be unlawful in Article 4.3 it is determined by the same law or some different law. And she says, this is about 10 lines up from the foot of 87, the third party's liability is dependent on the preliminary question of whether the board member, in her case, had unlawfully disclosed the secret within the meaning of Article 4.3b. And she suggests that that should be assessed under Swedish law, not French.
But excluding what one might have thought was the obvious answer, which is German law.
Well, she doesn't contemplate that, you're right. But the point that I was going to make to my lords...
It's not a facile point.
No.
Because if one's dealing with this by intuition, which is not necessarily a very good guide at all, why do you exclude Germany when the tipping takes place on these assumed facts in Germany?
Well, can I draw attention to a particularly important aspect of where we are in the analysis, which may be important to the question that my lords just asked me? We are still in Article 3b. That is one of the two subparagraphs dealing with pre-existing contractual or other duties, either not to disclose at all or to limit use. So at this point, the author is not actually addressing the question my lord was asking in paragraphs 65 to 67, which is how do you determine the unlawfulness of an antecedent act under subparagraph A. And the difference, my lords and my lady, between subparagraph A on the one hand and subparagraphs B and C on the other is this. Subparagraph A requires an earlier act itself to have been done and to have been unlawful. And the question my lord was addressing is how do you judge that unlawfulness? In contrast, subparas B and C are not about antecedent acts, unlawful or otherwise, at all. They're about pre-existing duties, contractual or otherwise. And where we have a contractual duty, one's in the realms of a voluntarily agreed obligation. So to understand what that obligation is, you look at the law of the contract. That itself may be expressly part of the agreement. The parties don't bother with an express choice of law clause. They're understood to have contracted in accordance with the accepted rules that identify the law. And either way, it's no different in the sense they've entered into a relationship, and all we're doing is look to see the law that tells one the nature of the relationship and the obligations voluntarily agreed. So we say there's no tension here. There's quite a different thing to be asking about the law that determines unlawfulness of an antecedent act. And what the author has done in her example is identify another special relationship which may give rise to a similar but strictly non-contractual duty. She might equally have chosen some special relationship of another kind, a fiduciary, for example. And to be fair to her, this is just scene setting. She's absolutely aware that she's looking at a different paragraph, because she then moves on to address the specific and different question that my Lord Justice Arnold was addressing.
Indeed.
And that's the point on 4.3a. But it is quite important to understand that her analysis there has got nothing to do with 4.3a. And we're now at the foot of page 87, and she outlines the Selgard case itself and identifies the issue relating to Article 4.5 as dependent on 4.3a. And crucially, the issue that we're concerned with is how one determines whether it's unlawful or not. The rival arguments put forward are summarised in the first back paragraph on page 88, and the effect of what my Lord said is summarised through the rest of 88 onto 89. Then the first full paragraph there, the author says she's confused a bit by the Selgard judgment, and she says particularly she's confused by the framing of the question as being whether the alleged infringer, the Chinese company, had used the trade secret unlawfully within the meaning of Article 4.3 by acquiring the trade secret, rather than whether the employee had used the trade secret unlawfully within the meaning of 4.3 by disclosing it. And what her point is, she goes on to make that Article 4, sub 4 and 5 are concerned with actions who she calls are actions of the tipper, not the alleged infringer. And by that she means the person one or more up the chain, as I've already explained, I think. And she also says, this is the end of the paragraph, so in the middle of page 89, the court stated the employee's alleged breach not to disclose the secret fell within Article 4.3a rather than what she thinks it should be, which is 4.3b. Now, I have to say, when I read this passage of my Lord's judgment, I had understood the discussion to be more of a general point about the structure of the section having this requirement in subsection 4.3a of an antecedent lawful acquisition and how that impacted on the overall argument on the choice of applicable law. In other words, I understood it was an issue that the existence of this provision was being used to test the overall analysis. But in fairness to Dr. Lundstedt, having seen what she said, I've gone back and reread it, and I've wondered if she's formed her view because the passage goes on and addresses counsel's attempt to answer the question. Because my Lord doesn't actually say what she says, but you can see, you're recording what Mr. Abraham said, and you can see why she's found it confusing, I think, because the submission of seniors counsel, they made a submission to the effect that it was China where the secret was acquired. But of course the acquisition in China was by senior, the alleged infringer itself, not the ex-employee Dr. Zhang. So I suspect she's read my Lord recording that submission and rather taken it that that's what was being focused on by my Lord, an alleged acquisition by the infringer as being under Article 4.3 when it ought to be the acts of the party she calls the tippers. And I'm having gone back again, I'm somewhat reinforced in that because when I reread it, I noticed she specifically refers, so about 4 lines down on this page, she specifically refers to the Chinese competitor in addition to the court framing the question in the way she's identified. Do you see that? So it's because the court and the Chinese competitor frame the question. So I think it's because my Lord's recording what was said by senior, and senior does seem to be answering on that basis. But as I say, overall, my understanding, and certainly my initial reading, was that this section of my Lord's judgment is just intended as a passage identifying the issue arising because of the structure and testing out the overall argument.
Well, it may be more than that, because Article 4.3a is framed in terms of acquisition. It says having acquired the trade secret unlawfully.
Yes.
It's not framed in terms of either use or disclosure, by contrast to other parts of Article 4, and indeed the directive as a whole.
Yes, but I think the point that Dr. Lundstedt's making is that it only rises because you're told to look there because of Article 4.5, and you're told to look there because you're looking for the act of somebody else. So if you're looking at Article 4.3 and asking about acquisition, you're implicitly asking yourself about someone who's not the alleged infringer. That's her point, I think, my lord.
Well, except that it comes in through the definition of infringing goods, because those are where trade secrets have been unlawfully acquired, used or disclosed. And acquired maps onto Article 4.3a.
I understand that. I don't think it matters to the central analysis that my lord, as I said, I've said it, I think it's right. I'm just trying to explain what I think the author here is saying she's been confused by.
Yeah.
And I understand her point to be you only go to Article 3 in this context because Article 4.5 has told you to, where you're asking yourself about the act of someone other than the infringer. So to start talking about what the infringer did, which Mr. Abrahams did, she's saying she was confused by. That's it.
Yeah.
It may also be a little bit because paragraph 68 of the judgment, which is included in her footnote as being the bit that she's relied upon. So although not addressing this issue, she's included in this group of paragraphs, her footnote 167, describing the vicarious claim, as I skipped ahead to before the short adjournment, suggests that this is a claim falling in subparagraph 4.3a. And as I think I indicated to my lord earlier, I'm not sure about that. Dr. Zhang didn't acquire the trade secrets unlawfully, as far as I can understand the Selgard case, but he then disclosed in breach of his duty and equity. Use by disclosure in breach of a non-contractual obligation is the non-contractual part of Articles 4.3b and c.
Sorry, I'm probably not getting the nuance of this, but surely you could say that Senior's a Chinese company, acquired the trade secret unlawfully and then used it. Article 4.3 is about use or disclosure.
Yeah,
and Article 4.5 refers back to used unlawfully. Isn't it? Can't you say Senior acquired?
You certainly could. The point that I understand Dr. Lundstedt to be making is that you only do that in the context of an exercise mandated by Article 4.5.
Yes.
When you're asking yourself about whether a different party acquired it, misused it. She may be right or wrong. I'm just trying to explain the
criticism. Well, we're limited in time, so I think we need to get on.
But I think she might have a point there about whether that claim strictly is under 4.3b or c, because that does include non-contractual obligations. But it doesn't affect the key analysis that she carries out and that my lord carries out. And as I say, my submission is that my lord was right, not her view. But I thought it right to try to explain some of the criticisms as far as I can understand them. Now, what she does at the foot of page 89 in her text is to explain the position in Sweden as regards this antecedent and lawful acquirement. So Article 4.3a, and we see at the top of page 90 that we see the Swedish government, when it introduced the new law, explain the question of tippers' foreign conduct, so that's the antecedent foreign act, should be defined by what Swedish law constitutes a violation. So that's the same conclusion as my lord. It's the same law as the main act, not the different one. And the author mentions another author, Falk, shares this view, and there's a fairly extensive quote in the footnote in Swedish and English taking up most of page 90. But the opposite view is expressed by Drexel, who I think is probably a German commentator, which is referred to in the first paragraph in 91. And we see the main point of contention of Drexel summarised at the end of this paragraph.
Is president of the Max Planck Institute. The relevant one. There are, of course, a number of others.
The main point of contention of Drexel, summarised at the end of this paragraph, is that the approach he favours, so that you actually go to a different law, avoids the export of EU law concepts to third countries. And can I deal with that head on? Because I've got two important points to make about that contention. What Drexel's referring to, as I understand it, is the idea that the acts in a foreign country are in effect being judged by the law of European countries, because something else has happened and then you're judging it in Dr. Lundstedt's example by Swedish law. And my first point is that you're only doing that to determine whether the products can be imported into and sold in the markets in the EU countries. You're only doing it for that purpose. It's not having any other effect more generally. No liability actually attaches to the antecedent acts. It's a way of judging the subsequent act. And the second, which I'm sure my lords and my lady are onto already, the Drexel approach most certainly imports the legal standards of third countries into EU countries. Because whether the goods can be imported and sold here, all round Europe, depends upon, for example in Selgard, it would have been the law of China. If it's not objectionable in that other country, all must be treated as fine and dandy in the whole of Europe. So those are the 2 points I make in response to the point that appears to be the main point from Drexel. And I say it's particularly inappropriate for a species of unfair competition to have it all dependent upon the law of some other third country, not the law of the countries where the markets that are being subjected to that unfair competition are located. Now, just to finish off what Dr. Lundstedt says, she continues in the paragraph at the foot of 91 to characterise the UK and Swedish approach, they're the same as I've said, as like a bundle of independent rights. And by that, what she means, I think, is that each market applies its law to the acts directly taking place there, and they do so to the whole factual circumstances, including those antecedent acts that have taken place abroad. And so there's no crossover in the sense that a conclusion under some other law about an antecedent act or conduct makes subsequent acts lawful or unlawful. And the contrast, Drexel's view is said, this is the top of page 92, to treat trade secrets like a factual monopoly protected against improper acts, where the initial unlawful acquisition or use infects the subsequent acquisition. I have to say, I think her description of the alternative approaches is a fair one, and I would submit one only has to...
As I think your point about that is, it works the other way around.
Exactly.
I mean, you can understand the logic of infection, but the converse is equally true, namely if the original acquisition was not unlawful by local law, you say, why should they immunise subsequent use?
Exactly. That's why earlier on in the analysis I've been anxious to emphasise that these points that people make generally work both ways around, and my lord's absolutely right. And I do say her description is a fair one, and I would submit one only has to read those summaries to understand, and to understand that it is a law of unfair competition, to realise that the former view, i.e. the one expressed by my lord in Selgard and reflected in the Swedish government and Falk's views, is the preferable one. But Lundstedt takes the opposite view, as she says in the second full paragraph of 92. And her first point is to suggest that my lord's approach in Selgard and the Swedish approach treats these articles as containing an implicit choice of law rule. And as I've already foreshadowed to my lord, I don't accept that either argument does. It's just one of those things that somebody seeks to say to criticise what the other person says, or might, and it's perhaps notable that the submission made by Senior's counsel trying to argue for this on the issue at that time was that it was an implicit choice of law rule. So either side can try to do that, but the reality is it isn't. Lundstedt goes on to argue that Article 4 is based upon a cascade of unlawful acts, where the unlawfulness of earlier acts infects subsequent acts. Now, of course, in a sense, that's right, because one is concerned with misuses of trade secrets and the unfairness of resulting competition, but it doesn't really deal with the point, the question of whether the dealing in products is wrong because the earlier act was the wrong or right side of the law. What standards are you applying? My lords, that's really the nub of it. In my submission, as I've already said, you and the Swedish government were right. Dr. Lundstedt's conclusion right at the end of 92, we can all agree with. It's a difficult question and the CJEU will have to look at it, but obviously not in a reference from this country. Now, my lord, that took some time. The upshot is, as I've explained, even if my lord was wrong, it doesn't matter because the main law is the Rome II law. But we say Rome II applies all the way through for the reasons that my lord gave and the ones that I've tried to offer by way of supplement. How does this all fit with our case? Well, and by it all, I don't just mean that particular wrinkle, I mean the entirety of the cell guard analysis. And I'm going to try to identify what's the same and what might be said to be different. And as my lords and my lady understand, the issue at the heart of our case is the argument about applicable law. In Cellguard, there were claims made in respect of acts which were importation and sale of products. I'm going to call them product supply claims. Each act of supply of a product is a separate claim. And in Cellguard, there was also a claim about the antecedent conduct which the misuse of confidential information arose from. And that took place abroad in China and led to, in a sense that it was necessary for the subsequent acts, led to the product supply claims arising. And I'm going to call those other acts, or the claims pertaining to those antecedent conduct claims. In Cellguard, both were framed as breaches of confidence, inequity, and breaches of the Trade Secrets Regulation, our implementation of the Trade Secrets Directive. In Cellguard, there was a contract, but no claim was made under that by the initial bad actor, Dr. Zhang. My submission is that all of this is mirrored in our case. Our claim extends to use by acts which one would characterise as product supply claims and antecedent conduct. What might be said to be different? Well, first, the key point relied upon by my friend in his skeleton, but not mentioned at all orally, is the products supplied are downloaded via the internet, not supplied on a tangible medium. Before he stood up, I understood that to be his big point, and I'll come back to it, but I rather detect he's not pursuing it at all. Next, what other differences? The other place involved in the picture is Latvia in our case, not China, but that obviously can't make a difference to the analysis. My friend's argument, if correct, would apply if the facts were the same and Latvia was replaced by any other country, China as it was in Cellguard, or let's postulate some other country with no significant trade secret protection at all. Don't need to speculate which that might be. So that's the second difference. Next, so thirdly, it might be said there's a difference between our case and Cellguard because the pleading in Cellguard expressly limited the product supply claim to supply in the UK. And that's, as I foreshadowed earlier, we haven't done that expressly here. And in fact, what we have pleaded is very general and brief. And let me turn up the pleading, please. It is the core bundle, tab 12. I'm going to look at the amended claim. So what the currently constituted claim. My submission is you don't get any help from looking at the detail of joint tortfeasance pleas that have been dropped. You've got to look at this pleading as it is now. And can we pick it up, please, at page 242. Now, it may be that we can be criticised for not having given more particulars, but look at what we said about the acts complained of. 13 through to 16. They have, after the termination, accessed the locked out part.
So that's Latvia.
Yeah. They have enabled other persons to do so.
That's Latvia.
Other persons working on behalf of On Air have accessed without the claimant's consent.
Latvia.
Yep. The fifth defendant and On Air have used the information acquired by their access as aforesaid without the claimant's consent.
Again, Latvia.
Well, perhaps more broadly. And then we go forward. We go forward to page 247. So here we've got the fifth defendant, breach of confidence and trade secret. So that's paragraph 22. The fifth defendant's acted in breach of confidence. Para 22 is the claim in equity. Para 24 is the trade secret regulation. Over the page, 24 to 27, they're just setting out the allegations of what's done rather than particulars. Over the page at 24 to 27 is the UK copyright infringement allegation that I have to say I was rather surprised my friend said it shouldn't be tried here. I don't, that doesn't seem to be in his notice of appeal. It was news to me. I thought it was accepted that that would be tried here, but my lords and my ladies know that I don't seek to rely upon that as in any way an anchor claim. The judge didn't rely on it, and I'm not seeking to persuade my lords and my ladies to do any differently. If we go to paragraphs 28 to 30, the allegation of confidential information misuse as against the fourth defendants, they're called On Air here. Para 31 is the trade secrets sorry, 30 to 31. So 28 to 30 is confidential. Is the obligations. The breach, sorry, is 30 and 31. 31 is the trade secret regulation equivalent. There's a reference to Article 3 of the regulation in paragraph 31 there. That covers all kinds of use in the directive. Use is mentioned in the second line, and Article 3 covers all kinds of use in the directive, which includes Article 4.5 use. Para 32 is vicarious liability, and then we come to the relief section, which is where you really get the guts of what we're complaining about in terms of the key commercial damage. And that is focused on the acceleration of what are called derivative games, which are competed in the competitive environment, i.e. the market. This section actually goes on and suggests there should be a springboard injunction Of course, whether that would be granted after trial would be a matter for argument.
Well, the judge held that you had no case for an injunction and you haven't got a respondent's notice on that.
Well, he allowed it in the pleading, and I have to say that I think there's a difference on gateways. You have to take a view as to whether you're more likely right or wrong, I think. So I have to say, when I listened to my friend's submissions on that, he didn't really explain why he allowed it in the pleading. And my own understanding is that when you're looking at a gateway, the question of good arguable case there, if you meet that, is you've basically got to show that you're right or wrong. But I do understand what my lord puts to me. I'm not actually relying upon it for the fact that it's going on to ask about a springboard injunction. And what I do say is the point that my friend made about the fact that, particularly by the time we get to trial, the products, our own products, have already been released. That doesn't affect whether or not they've obtained a significant advantage by using the trade secret to accelerate the availability. And that is what the essence of this is all about, the acceleration of derivative games to compete with ours in the competitive market. Now, it is not expressly limited to suppliers of games to UK-based punters when they download and play. But the substance of it is punters downloading games via the internet. And our business is UK focused. And here I'm not relying upon the fact that I'm a UK based company with bank accounts here. I'm talking about
But this is, if we look at subparagraph C, it says the fourth defendant has sought to accelerate the development of its live online games, starting up its business. But the fourth defendant operates exclusively in Latvia, and there's no plea that it's done anything outside Latvia.
Well, the fourth defendant has arrangements with platforms.
Where is that pleaded?
It's not specifically pleaded, but everyone understands.
Well, excuse me, if it's not specifically pleaded, it's not pleaded.
I understand. What I'm showing, my lord, is that the general plea does clearly contemplate that. And I'm going to say to my lords and my lady, the judge understood that. My friend understood it in coming up with his intangible, tangible distinction. Because why is that distinction even made?
Sorry, what are you saying is understood? That the fourth defendant
the way in which
did what?
both
UK?
both of these, as I've understood this business, the way in which you make money is that you have arrangements so that your games are put on bookmakers' websites.
Well, that may be true, but your understanding is irrelevant. The only thing that's relevant is what's pleaded, and there's not a dicky word about bookmakers in this pleading.
There is a reference to bookmakers in the judgment, and there's a reference to bookmakers in the evidence.
Yes, but the judgment is under attack.
I understand that. But my submission to my lords and my lady is that the scope of this pleading is broad enough to be understood as including that aspect of the business, which is the one that actually matters, that the attack of the unfair competition, which means that my clients reduce their revenue because there are competing games on the market more quickly, and that is the thrust of what we're pleading in the springboard part. Now, I totally understand the criticism that it hasn't expressly said this particular one was downloaded to these customers in the UK. I understand that, but the pleading does encompass...
It's not just that it doesn't say anything about any particular games being downloaded to the UK. What's even more important is that there's no suggestion that even if such a game had been downloaded to the UK, that the supplier was anything to do with these defendants.
Well, as I've said to my lord, as I've understood this, everybody has arrangements with bookmakers to put their games on these platforms, and I totally understand if the criticism is we've got to plead this more specifically. I totally understand that. But what I'm saying to my lords and my lady is that this pleading was understood by the judge as directed to that, and was understood by my friend. And that's why I keep expressing the point that my friend came up with this distinction between an intangible supply and a tangible one. And he knew that the supply was part of it. Now,
even if you leave the bookmakers out of it, isn't there an earlier problem that what the pleadings, or at least an earlier version of the pleadings, seemed to indicate is that Realtime does the development, but it's Games Global who does the supply of the games. So even if you left the bookmakers out of it, don't you have to address that? You may say that's all gone from the revised pleadings, but there is a point that actually we're trying to work out whether the judge got it wrong in his judgment, so possibly the earlier set of pleadings are relevant.
I understand that point as well. But in my submission, that doesn't mean that looking at this pleading, you take the view that what was raised as a possibility before is definitely right, and therefore this pleading encompassing use under the Trade Secrets Directive, which includes supply of products, doesn't encompass it.
Well,
Sorry, I don't agree with what you say about the appellant's case. Can we look at the skeleton argument? It's called bundle page 40, paragraph 49. What they say there is, in the present case, the acts of breach of confidence, misuse of trade secrets complained of, with the alleged access to confidential material on Horizon, vast majority of which occurred in Latvia, none of which in England and Wales, and the alleged use of the confidential material to develop competing games, which occurred exclusively in Latvia. And then it says, C1's pleading in evidence does not identify any relevant acts carried out by D4 and D5 in UK, and that is the core submission made to us by Mr Moody Stewart this morning. And then it goes on to say, although C1 refers to games developed by D4 being made available to users in the UK by online bookmakers, and he refers to the old 38K, because of the date this skeleton argument was filed, no doubt that was still the current version, but that's, as you yourself have accepted, that's been superseded, and the old 38K isn't even there anymore. But even if you disregard that, they go on to say, these online bookmakers not part of the claim, no suggestion their acts are wrongful. So this is nothing to do with any distinction between physical and intangible. This is all about, you haven't pleaded any relevant acts carried out by D4 and D5 in the UK.
Indeed. But if you go on, they make that point too, but they also understand the thrust of it is about the placing of products on the market. If you go on to paragraph 50, the position is completely different to Selgard, and they say that the key point of Selgard was the claimant was complaining of specific acts of unfair competition taking place in the UK by importation of tangible goods into the UK.
Yes, but you have to look at what they say in the last two sentences. In the present case, goods are intangible, that's your point, okay, which can be downloaded from anywhere in the world, including but not specifically related to the UK. So this is the familiar accessibility versus targeting distinction. And then they say, C1 is only alleging indirect consequential damage to its business in the UK as a result of acts occurring in Latvia. So again, the essential point is not to do with intangible versus tangible, it's to do with no acts in the UK, no direct damage in the UK.
Not here, my lord, in my submission. that their conclusion is that it's only indirect consequential damage because it's intangible, and they say that makes it like the vicarious claim in Selgard. And here they are saying that the key difference is the supply over the internet, because you can get it from everywhere. And what I say about that is that can't be right, because each supply to different punters is an individual supply, and it can't be right if
sorry to interrupt you. You keep on talking about individual suppliers to punters, but there are none pleaded. How do we know, on the basis of your amended particular claim, that there's been, and we know this from the particular claim, there's two particular games that are complained of. How do we know that there's been a single download of those anywhere in the world? But certainly, how do we know that there's been a download of them in the UK? It's not pleaded.
Well, other than the general plea in the relief, which is talking about the competitive.
So you say that's enough?
Well, I do. And what I say is that we all know that the centre of gravity of our business, when the judge says our business is in the UK, he's not talking about how our bank account is. He's talking about the fact that we've got, he mentions William Hill, and I think the evidence mentions another bookmaker as well. Our business...
I'm sorry, but that's not to the point. There's absolutely no dispute that your client's business, you're an English company, you have a UK business. That's not in dispute. But you can't say, because we're a UK business, therefore we suffer direct damage, can you?
No. I say
you need to point to UK downloads.
What I say, my lord, is the business, our market, centre of gravity is the United Kingdom. It's the UK bookmakers. What I say is that springboard pleading is talking about the availability of their product and the diminishing use of our products in the competitive environment that we're working in. So that is, in fact, I totally accept that if standing here today, knowing what the argument is I have to meet, I'd plead this much more specifically. I'd plead that you can infer that there have been downloads. I'd plead all of that. But what I do say to my lord is that it's within the scope of the pleading, which has not yet descended to that level of detail. It's within it. And if you fairly understand that springboard and you know the basis that our business is focused on the United Kingdom, we both use the same platforms. That's the reason that the bookmakers have not been sued. We both use them. And if you understand that, which we say the judge did, what's happening is that the supply, download to punters and use UK-based punters. I can't say, and I have not expressly excluded non-UK. And for instance, I don't know whether my lord or my lady picked up, but these games are a mixture of computer games and hosts on a video feed. So they'll be speaking English, and although they're based abroad. So the reality is, there might be users outside, and particularly Ireland, one might think there might be. So I haven't limited it in that way, and I say it doesn't matter. But the guts of it is about the competition where our business is, and that is the guts of that springboard pleading submission. Fairly understood.
Right.
Now,
can I ask you a different question? Because I've been focusing very heavily on the statement case, and at an earlier stage you were talking about evidence. Can I ask you this question? Does your client's evidence contain any evidence that the two games complained of have ever been downloaded to the UK?
I don't think so. I'll check. No. But it would be.
So it's not merely a question of pleading, because if you tried to plead it, you couldn't because you don't have any evidence.
No, I don't think that's fair, my lord, because knowing which punters have logged on and downloaded a different game is a difficult thing. One could fairly infer it if it's been made available on a UK bookmaker's platform. So I don't accept what my lord said to me at all about that. I could.
Well, you've just accepted that you don't have any specific evidence.
No, because I don't have a day. I can't say Mr. Moody Stewart was playing roulette on a particular day and this is what he downloaded, or any other member of the public.
No, yes, but you wouldn't have to identify who the recipient was, because there are technologies that exist in this kind of context that will allow you to detect downloads even if you can't identify who they're going to.
Detect a download from, say, William Hill website.
Well, it depends. It depends.
I'm sure.
Obviously, one would have to be careful because it might involve unlawful activity if you're not careful. But
all I would say to my lord is that we haven't specifically tried to say we know that this game was downloaded on this day by someone whose identity we don't know, but we've monitored something. We haven't tried to do that. We haven't even tried to specifically plead it, as you're all aware. And in my submission, that is a bigger problem for me, not the point that my lord is now putting to me. I don't accept that I couldn't specifically plead the detail by inference when it's if a game is made available on a UK bookmaker's website, I don't say that I can't, or don't accept, sorry, that I can't plead an inference that it was used by the UK punters.
But I might need disclosure of some kind to find that out.
Indeed.
Can I ask you a slightly different question, which is what we're focusing here on D4 and D5.
Yeah.
Do you say that D4 or D5 supplied the software to UK punters? Not do you plead it, but is that your case?
My case is that this is a kind of platform where these products are put onto bookmakers' websites.
I understand that. My question is, who's pushing it on to who's giving it to the bookmaker? Is it D4 and D5? Because I thought your case was, it wasn't. It was D1, 2 and 3 who were doing that.
Well, it's being done through all of them as an entity, as I understand it.
but they're different groups. Global Games is a different group to Realtime.
If I've understood the story correctly, your case is D5 unlawfully accesses confidential information and gives it to his employer, D4. D4 uses it to develop games sooner than they would otherwise have done.
Yeah.
D4 then gives it to Ds 1 to 3 in some form, the details of which don't matter. They give it to William Hill, and William Hill makes it available to the public. Have I understood that?
Well,
or is that wrong?
yeah, I suspect that none of that actually happens in the formal giving. My instruction solicitor reminds me that actually the detail of what was alleged is that sometimes they're actually inconsistent. Sometimes they say it's on air, sometimes they say it's the other one.
Yes, but the difficulty for us is that the judge is not allowed D1, 2 and 3 to remain in the case. So the case is only proceeding against D4 and D5, and as a result you've amended your pleading, so it's got rid of the on-air ambiguity. It now just talks about what D4 has done.
Sure.
And I don't see, maybe I haven't seen it, but I don't see that it's said that one of the acts complained of is that D4 has made these games available itself to the UK public. And I could understand your case if your case had pleaded that D4 had imported, in the way you explained, into the UK. But I don't see it. Have I missed it?
No, I totally understand the problem that my lord is putting to me. All I can say to my lord is this. The reality is that there might be a contractual arrangement of the kind that you identified, in that it goes one way to the other. There may be a contractual arrangement, but certainly they were inconsistent as to which ones were supplying any particular game. And the reality is probably, although we don't know until we get disclosure, but the reality is probably that the developer just passes it onto the website where it goes. But I can't specifically plead any details to support that. What I do say is that you shouldn't discount that at this stage, and it is within my pleading that D4 is undertaking all of the uses in Article 3 of the regulation, which are all of the uses in the directive, which includes Article 4.5. It's within my pleading.
Well, I think I understand the way you put it. Thank you.
Now, can I pick up the judgment and can I pick up the judgment, and I want to pick it up, so it's tab 7. Can I pick it up at page 90 of the bundle, so page 100 onwards. And here we see the judge identifying breach of confidence as a species of unfair competition. And he identifies the applicability of Article 4, Roman 2. Paragraph 101, he turns to Selguard, and after setting out Article 4, he summarises some of the key effects of my Lord's judgment in Selguard. First, he identified the key claims, that's para 103. Para 104 is important. There, the judge is identifying my Lord's key conclusion as to the acts of unfair competition, the subject of the direct claim. So that's for the acts of importation and marketing. It's where the UK is the country where the direct damage is sustained. So following Rome 2, correct law is English law. And he completes the paragraph by summarising the contrary conclusion in Selguard as regards vicarious claim in Chinese law. Now in paragraph 104, the judge mentions that it would be possible that Mr Veliks' acts in Latvia could also have effect and therefore be regarded as being carried out in the UK. And he gives an example of what he's thinking about here, whether the servers are here. And it's one of those points where if somebody's doing something on a computer system that's distributed across different countries, you might consider...
But since they would be your servers, you would know where they are, and you haven't alleged such a thing.
No, I haven't. And he doesn't, he says I haven't got evidence of that. But all he's doing is saying that might be possible, but that's not the way I'm going. And he says he should focus away from that point following Selguard. So he's focusing away from where one considers the acts are done, or considered to be done, to the question of where the damage has or will be sustained. So he's expressly saying he's following Selguard. Then in 106, the judge explains that whilst Playtech hasn't identified competing specific imports, as was the case for the direct claim in Selguard, this is understandable because it's different. It doesn't sell physical goods but intangible products. So he's specifically identifying the issue my friend said in his skeleton made the difference. And he goes on and says, nevertheless, it seems to me he's got close enough to the direct claim in Selguard. And he explains what he means, facing competition to its business, which it conducts in the UK in relation to sales from at least one game relied upon as confidential information in relation to its sales. So what he's talking about there is we are facing competition to our business in the UK. That is the judge understanding the substance of what I've tried to be submitting to my lords and my lady. It's not about the use of a game that then doesn't see the light of day. The focus is that our business is being unfairly competed against, the business we conduct in the UK. So correctly in my submission, he's focusing on where we're facing that competition, which we say is unfair, and he said, and it would be if one feature had been relied upon, which is a trade secret. He then addresses the vicarious claims against the fourth defendant in this case, and the suggestion that it may be treated differently, as was the case for the vicarious claim in Selguard. But he says
to ask you a slightly different question. I mean, it may not matter in the scheme of things, but one of the things I find very odd about this is where does he reach a conclusion as to the applicable law? Because he begins all this, I mean, Mr. Moody Stewart told us that there was nothing about Rome 2 in the original draft, which might explain this. But he begins with Rome 2, which is about applicable law. He goes through Article 6 and then Article 4. He goes through Selguard, but where does he reach a conclusion as to the applicable law for this case?
I have to say, I thought that's what he was doing here. But
Really?
yeah, I have to say, I think that I'd understood that's what he was doing here, but that's perhaps because of the way the appeal was framed, and I thought that they were attacking this part of the judgment.
At the moment, I don't see any conclusion on applicable law at all.
Well, in substance, that's what he's deciding. I do recall seeing something in the transcript where I think somebody was saying 2 paragraphs of the relevant gateway were the same because applicable law and where the damages sustained it amounted to the same question. I think it might be the point that, in fact, my lord put to Mr Moody Stewart and he accepted it.
The other troubling feature of this is all done in the context of Gateway 9, which it is common ground is not the right gateway. Now, in itself that doesn't matter because he repeats the same analysis for Gateway 21, which is the right gateway at 115. But nevertheless, it reinforces my concern that he's not addressing his mind to the right question, because he sets out Gateway 9 at paragraph 96, and it's all about a claim made in tort and where is the damage sustained. And so by the time he's got to 106, what would you say to the proposition he's actually forgotten the question he's supposed to be deciding?
No, well,
because he's supposed to be deciding what the applicable law is, and he's gone back to Gateway 9, which is not what he's supposed to be deciding.
in my submission, the point about Gateway 9 and 21 is not a significant one. He clearly deals with it under both, and they're in substance the same subject to Mr Silverleaf's point about the wording that my friend said he wasn't relying upon. I suspect that happened because under English law, breach of confidence is not a tort, so we had to have Gateway 21. But under the European law for working out these things, I think it is treated as tort or deal.
No, it's not. It's treated as unfair competition. And under most civil law systems, unfair competition is not a tort.
Right. I thought... your lordship's probably right. I thought
that's why you have Article 6.
I thought there might have been something in the old Brussels Convention. That, anyway, so not Rome, but I might be wrong about that. But there was certainly some, maybe it's an earlier case where before we had the new gateway where it was treated as a tort, wrongly as it turns out. But the bottom line, my lord, is that really, he's clearly applying the same gateway because the words are in substance the same. He's doing it twice over. So in my submission, you can't say that there's a further concern because he's put it under Gateway 9 when he's just repeated what he said later on under Gateway 21.
Can I ask a really basic question? Looking at Gateway 21, which is the correct gateway, there are 4 different alternatives. That's on page 92. Which are we looking at, or which do we say the judge was looking at?
I have to say, I will send it over because I'm pretty sure I've seen when I was reading the transcripts, him saying A and D are therefore the same. And he's talking about A and D here, the detriment being suffered and the obligation, the law of the obligation. So,
well, he may be saying that. Is that your position?
Yes. He's doing both. And I want to make sure that that's right because that's just a recollection of my reading part of the transcript from a few days ago. My lords and my lady will understand I wasn't actually at the hearing, and so I can't tell you from a personal recollection, but I think it was raised in the hearing from my recollection of reading the transcript that A and D are the same. They collapse to the same point, and I will make sure that we check that that's right. So he is dealing with both here because he was told at the hearing that they're the same thing. And in fairness to the judge, it can't seriously be suggested that when he says he's following Selgard, he didn't understand that that was a case on choice of applicable law. That's never been suggested, and he clearly says he's following Selgard. And so, although he doesn't say, my conclusion is the applicable law is, I understand that from what my law's just said. A fair reading of this section where he says, right, the right law is Selgard, this is what I've got to do. Surely the judge can't be understood as not even understanding that Selgard is a case directed to applicable law.
Yeah, you say it's implicit.
Yeah, it is implicit. Now, my lords, my lady, I think I was at the point where he'd said he doesn't think.
And forgive me, Selgard was not itself a case on the gateways. I should have picked that up.
No, it wasn't. It wasn't an issue.
Okay, so it's on the forum.
Well, it came in a different way because the argument was raised under the heading of serious issue to be tried. The serious issue to be tried depended upon applicable law. So it was the same argument, but in a different guise.
Yeah, but it's nobody can read Selgard and not understand that you're following a case about choice of applicable law. My submission.
I would hope not.
I think I was at where he was just turning to the vicarious liability and whether it should be treated differently. And he says he doesn't think so, or at least not entirely so. And then the next two paragraphs actually explain why he's saying that, because he's kind of saying yes and no. And he gives you the why it shouldn't be treated differently, i.e. should be treated in the same way in 108. And the alternative view is 109. And 108 identifies that it was a very specific basis of the various vicarious claim in Selgard that mattered. The damage was the disclosure itself. Contrast here, where he's identifying that even that claim, he says that here it's framed by reference to the same damage as the direct claim, the economic loss through the unfair competition. And that really, my lord, it reflects what I tried to submit to my lords, my lady earlier, in that the reality is our business is UK based. And I don't mean that where the company is, I'm talking about where the market is. And whether it be the vicarious claim or the claim linked to an actual sale, the reality is the real damage from both of those is this. And he's recognising that in my submission. And it really drives it home here. What he's got in mind is economic loss through unfair competition. And he's saying that flows actually from the acts in Latvia. And what he's focused on there is that's basically the point of why they're doing it, to compete with us where our business is. That's what's happening. That's what we're complaining about. And in a very real sense, that is direct loss of that act as well. And that's what he's saying in 109. And he says it, sorry, in 108. And in 109, he's saying, if you look at it the other way, that what the complaint is really about, the disclosure or the use is just the disclosure or the use itself, then obviously it is Selgard. Vicarious claim. But that's what he's doing in 107 through to 109 in my submission. He's actually finding that even for those claims, the acts in Latvia, the direct...
Explain that. So how is Mr Veliks liable for the loss that you claim in the UK?
Well, what he's saying is that it still matters where the real damage pertaining to those acts is sustained, and that his view is that it's all about that, so that is the direct loss. And I would explain, the judge doesn't, but I would explain it as this is being done to launch a product that competes with ours.
Sorry, Mr. Veliks is said to have wrongfully accessed and wrongfully disclosed information to his employer. How does that lead to direct damage in the UK?
The whole point of it, the whole point of why he's doing it, is to develop.
Yeah, I'm trying to understand what the judge's answer is, because he seems to say in 109, look at it holistically, and I'm asking, what does that mean?
No, sorry. 109 is where I'm focused on 108. I'm looking at 108, so we're at cross purposes. 108 is where he's saying that the vicarious liability claim shouldn't be considered like the Selgard one, where the loss was the disclosure itself. And he's explaining why. So my submission to my lords and my lady is that 109 is basically a conclusion that it's the same damage that matters, that is the direct loss of even the Veliks acts, because it doesn't go on to explain why, but my submission would be because that's the only real thing that's actually happening, and it's actually intended. That's the whole point. But the point is to look at what we're going to be doing in the UK market to launch a competing product in the UK market. So the submission that I make is that even an act outside, so in Latvia, even an act outside where those are the circumstances, that is capable of constituting the direct damage. It's not the same as Selgard, where it was just a disclosure in China where you develop something which may or may not end up being exploited in a different country, and then they find out that UK happens to be where it's going to happen, because there was a specific customer that I think was going through pre-qualification, if I remember rightly. It's not the same. This is a case where this has been specifically accessed, our confidential information, to look at in order to compete with us, and that necessarily means that what they're going to be doing is unfairly competing, causing economic loss in the UK. And paragraph 108 is explaining why he says he doesn't think it's quite so, that that claim should be treated differently. But 109 is dealing with the other side of the view. And what he's saying in 109 is really no more than what went by concession in Selgard, which is...
But it's not conceded in this case.
Indeed, but I would say that it would still... Nobody's ever mentioned Gateway 4A, but that's the substance of what was happening.
Gateway 4A wasn't relied on.
No.
It's too late to rely on it now, isn't it?
Probably, I don't... What he's doing, my lord, is just basically saying that, well, actually, perhaps what he's doing is, if you look at it the other way, it would be just the disclosure, so that would be outside. But I'm going to look at all of it, and the reality is, paragraph 108, that the substance there is the real direct damage, the real damage that matters. So those two paragraphs really matter, actually, in my submission, because it makes... The reason that their importance have increased is because I came here to meet the argument about intangible, and I've been met with a really extensive attack on the pleading, and I understand that, and I've tried to explain to my lords and my lady why it's within what we've pleaded. But if you're against me, and it actually has to be a specific plea of a specific download or a specific supply that I haven't done, these paragraphs say or explain why I still win, because 108 is still saying the judge's assessment is that that damage is still the direct damage of those other acts outside of Latvia on the facts of this case. And it's not sufficient in my submission to simply say, well, it was an act done outside of the UK, so damage in the UK can't be direct. That's the whole point of the structure of Rome 2. That it's a different place, quite possibly. It's not sufficient to say all these other acts, well, you haven't pleaded anything specifically, but we can go through and accept that you're alleging this, that and the other in Latvia. It's not sufficient to say, well, that's it, so there can't be any direct damage in the United Kingdom. There can be. And the judge is saying that this competition in this country, the economic loss that we're going to suffer through it, is a direct loss of that part of the claim as well. And, my Lord, let me turn the question around and just ask you to consider this. Because my friend keeps saying Latvia, Latvia, Latvia is the place. What actual damage have I suffered in Latvia? Of course he could say, well, we were doing something with your trade secret. Disclosure as such can be damaged. But the reality of what we're complaining about, what actual damage have I suffered in Latvia? And that is an instructive way of looking at it in my submission. Because the answer is,
Well, you can only make that submission because you've removed your subsidiary which is incorporated in Latvia.
I'm not sure that's right.
Doesn't it rather suggest you can't be said you've got no business in Latvia? You do have a business in Latvia, sufficiently to make it worth having a company there.
I think they were the contracting company that employed people, but I might be wrong. Yeah.
Right, okay, so they don't actually have a trading business.
It's not a trading business. Yeah.
All right.
I think they were there because they had the contract with Mr Veliks. So certainly, I wouldn't have been making the submissions to my lords and my lady about.
It's not what the judge says. He says that EuroLive designed and developed online gambling games.
Yeah, they employed people in Latvia that did it. So, but they didn't. There was no market. The punters aren't there. That's the point I'm trying to make to my lords and my lady.
Isn't?
Why not? Why would there not be punters in Latvia?
Because I can't say it's impossible for somebody to do it in Latvia, but the reality is this is UK bookmakers.
Surely this is a global business.
Well, the reason I said to my lords and my lady that there's a host, because they'll be in a language, so sure, there will be people in Latvia.
Quite a lot of Latvian people speak pretty decent English.
I'm not standing here and saying nobody in Latvia has ever... The judge held that our business is in the UK, and what he's talking about is what I've been trying to submit.
There's another point.
Yes, certainly.
You talk about direct damage. Our businesses here, we've suffered loss here. I understand that, but it seems to me what Article 4.1 is getting at is the difference between what they call direct damage and indirect consequences. Those are the words used. And I think the point being made against you is that there are too many steps in the chain, if you like, that haven't been addressed. So you have clearly pleaded wrongful acts in Latvia. But what isn't pleaded is what happens then that results in your loss in the UK. That seems to me to raise this point about indirect consequences. Even if you take your point entirely that your business is a UK business and you have suffered loss here.
I understand the point that my lady's putting to me, and it's in a way it's a more generalised way of putting the point that my lord put to me about the other entity perhaps being an intermediary.
It's really about the meaning of damage and what colour the words indirect consequences.
Let me be absolutely clear, and the reason that I'm not making the submission that was made below, but the judge didn't accept that it's good enough if we're based here and our bank account is here, that is not good enough. What I am doing is I'm focusing on this tort is about unfair competition, which means it's where the market is. And I do rely on the fact that my market is here. The punters are here, subject to spillover of the kind that my lord identified. No doubt will be the odd Latvian that might go onto the William Hill website and play roulette or whatever. But the centre of gravity of our market, and therefore the unfair competition that we're suffering, is the UK. And to answer my lady's question, in terms of whether it should be viewed as indirect consequence or direct, I do rely on the fact that they're doing it deliberately to look at our game where our market is here. So to suggest that, oh, this is just an indirect thing that's arisen is not a fair way of looking at it in my submission, and that's not what the judge was doing in 108.
Yeah, okay, well I think we've got that point. We're running out of time, so we should allow you to address Article 4.3 and proper forum.
Yeah, Article 4.3. Let me just find in the note. Article 4.3 is, as you've seen, in effect a get-out clause to disapply the conclusion on damage and conclude it's Latvia in this case nonetheless, because what you'd have to conclude is it's manifestly closely connected to that. And we've dealt with that point of paragraph 48 of our skeleton. And it's basically an argument that the basic rule applied in Salgard could in fact be disapplied because the antecedent acts took place outside the market where the actual unfair competition was subsequently felt. And really, in my submission, particularly in a case like this of unfair competition, where you've seen that the whole point of the legislation is to have the possibility of a separate laws applying to different acts. What they're trying to do by this is to suggest that you go back and you, in effect, do what Senior were urging on my lord in Salgard, which is to just go back and consider that it's all where the initial acts were undertaken. And in my submission, that's not the right approach at all, particularly in the case of a tort of unfair competition. It really isn't all about Latvia. And that's why I asked the rhetorical question of my lords and my lady, where's that unfair competition actually being felt? Where's the damage being suffered? It's here. Can I? Sorry. No question. Can I very briefly deal with the forum grounds? And I've addressed them in some detail in our skeleton, so I'm going to take this as quickly as I can. The introductory remark I make is that this is a paradigm issue for the evaluation of the first instance judge. And I don't believe there's anything between us on the correct legal approach. What my friend has done is identify 5 separate errors of principle, although one is just a repetition of what we've been through, so it's really 4 extra points. The first contention is the judge got the burden of proof wrong. We answer that in our skeleton at 52 to 59, and it's obviously a contention that's based on the fact that my friend, this is a service out case, so the burden is on my clients. But implicitly, it must be my friend's contention that the outcome depended on the burden of proof, and you'll have seen that we identify what the judge said about that in the permission to appeal stage. He said that it didn't at all. So that is a short and sweet answer. The further details that my friend relies upon are just snippets taken out of sentences. One is actually about where the witnesses might be located. and he said that he didn't see that as a strong reason to litigate elsewhere. That is nothing to do with burden of proof. That's his assessment of the weight of that factor. And it was because there wasn't one single place where the witnesses were outside the UK. There was some in Latvia and I think some in Malta. So that's an unfair reading. The other snippet is from his conclusion paragraph, where he says that the case hasn't been made out. But he also says that his conclusion is that the United Kingdom, or England and Wales, is the correct forum. So that's a flimsy basis, just that sentence in my submission. I also have to address very briefly the point made on the Latvian evidence, because that's a third thing relied upon this, because he identified a lacuna in that. And in my submission, that is nothing to do with getting the burden of proof round the wrong way. The other side elected to put evidence in, but they did not explain that a UK-based company could bring a claim in Latvia for damage suffered in the UK. And we relied upon that and pointed it out. It wasn't a major point, and the judge just said he was reinforced in his view because there was a lacuna. Reinforcing in a view is not the reason for having it in the first place. So none of those points, either individually or cumulatively, are any reason to think that the judge was applying the wrong burden of proof. That brings me to 2C, because B is the repetitious one. And that is an argument that the overwhelming majority of wrongdoing took place in Latvia, and the judge failed to take that into account. We've got two answers to that. They're in our paragraph 61. The first is the contention is built upon the same premise underlying the governing law argument, and it's only about access and use in Latvia, and we've been over that. And the second is that the judge actually, in substance, was taking that into account when he was considering where the witnesses were. The witnesses that are in Latvia are there because they are alleged to have been doing the wrongdoing, and he was taking that into account. That brings me to 2D. The substance of what's advanced is all to do with the Latvian law contract and the termination agreement. And the argument there is that that may have some relevance, as I understand it, something to do with offences. And the key part of the allegation is probably that you see in 68 of my friend's skeleton, all about the scope of the obligation of confidence which applies under the contract. And that's just not relevant, as the judge explained in 36 to 38 of the judgment. We're relying upon English law. And it's not a contract even between the plaintiff and the claimant. It's another Playtech group. The final point we make under this limb is to point out that the argument really does have a bit of a, well, more than a bit, a strong hint of the kind of point that a party seeks to argue or proceed as if some other claim had been brought on the contract. That was specifically highlighted by Lord Justice Davis in that short judgment at the end of the Selgard case. You can't do that. There is no claim in contract. And my lords and my lady, that brings me to the last one. I'm taking this as a right canter, but that's the disclosure would be available in England, which is more wide-ranging. We've addressed that in paragraph 71 to 73 of our skeleton. Sorry, it's in my friend's paragraph 71 to 73. And the judge was wrong to consider it relevant at all, is the contention put there. My friend rather moderated that in his submissions to suggest that he's given it too much weight. There's a suggestion that the language the judge used was suggesting Latvia was inferior. My lords and my lady would have seen that we absolutely accept it's not language we would use, but that's not the point the judge should be understood as making.
For non-convenience, the extent of disclosure available is normally regarded as not being a factor.
It's
you
not
have to take the litigation system in each country as you find,
it's not precise.
Unless you can show that you won't get justice, which is not your case.
No, that's not my case at all. It's not. my submission is that when you look at the quotes from the Spiliada that we've included, it's not quite the way that my lord's just framed it. It's not decisive, and simply a juridical advantage like that is not enough, but that is not the language of it not being relevant. And there may be cases, and we say that a case where you need to get to the bottom of the full extent of the alleged wrongdoing, like this, could be one, where it can be relevant, because leave aside the interests of the parties, because what's in one party's interest is in the other party's disinterest, but that quote refers to the ends of justice as well. And all I say, and we put it no higher than we did below, it can be relevant, and the judge is doing no more than taking it into account like that. And he's certainly not deprecating the Latvian system, it's just different. But in our case, it may matter, and that's a factor, but it's nowhere near a decisive one, and the judge wasn't treating it as such. And that's perfectly okay in my submission. It's in accordance with those quotes from Spiliada. Now, I think I've got to the end. Is there anything else that any of my lords or my ladies want to ask?
No, thank you very much. Mr. Ladies Chair.
My lords, my lady, briefly, the first point I'd like to address is my learned friend's suggestion that in some way he's been surprised or ambushed by the approach I've taken on this appeal in relation to the focus on the pleaded acts and whether there was any case in relation to acts giving rise to direct damage within the UK on the pleading. The Lord Justice Arnold identified the part in my skeleton which flags up this point at paragraph 49 that we say there are no acts by D4 or D5 that are properly pleaded in the UK. But the reason why I focus so heavily on it today is because it was only when I saw my learned friend's skeleton where he raised for the first time the suggestion that this was all about downloads, this was all about supply, that I realised that that's what case he was now running. And just to make good the point that it was entirely new in the appeal, I just show, my lords, my lady, the submissions suggesting permission to appeal should be refused, which are behind tab 14 of the core bundle, which is the case until the arrival of my learned friend skeleton that we thought we were meeting, where in relation to ground one at paragraph 3, so we have ground one sets it out, and then paragraph 3, it said the claimant's case was that because all of its trade was conducted from the UK, the place it will suffer damage of unfair competition by misuse of confidential information taking place anywhere in the world will be in the UK. Any sales lost or competitive disadvantage caused can only have been lost or caused in the market in which the claimant trades, the UK. So that's the impermissible approach. The present case is distinguishable from Celgard and Kai Technology on this fundamental basis because business trading in intangible property, you can see why I thought they were keen on intangible property, the only place where any damage can be suffered is in that jurisdiction from which such trade takes place, which for the claimant's business is exclusively the UK. Where trade takes place from only one jurisdiction, there is no material distinction to be made between direct and indirect loss, cf. Celgard. Accordingly, the court's conclusion that Article 4.1 of Rome II regulation dictates that UK law applies is unimpeachable. So the suggestion was that direct and indirect loss doesn't matter. The distinction is immaterial here, and that is absolutely not the case that my learned friend is running now. Now, for the first time on his appeal skeleton, he said, well, actually, there is something that gives rise to direct loss, but is not something that is pleaded or supported by sufficient evidence to pass the Kawasaki test. So, which brings me on to the second short point on appeal, but that was really just to address the suggestion that somehow I pulled a rabbit out of a hat on this. It's been front and centre of our approach from the beginning. The second point is in terms of the pleadings. My learned friend took you through his statement case, and he skipped over the only particulars given of misuse. He went from the allegation, the broad allegation of use by access and then use of development and launch. He skipped over the particulars and then relied in paragraph, I think it's the broad allegation, and so behind tab 12, he was looking at the revised particulars. He relied in particular when referring to on-air's breach of confidence and trade secret, he said, if you look at 30 and 31, so this is on CB2, page 250, he said, so there's by reason of the acts about which complaint is made herein, which are those specific particulars which he didn't show you, but which know nothing at all about direct loss or importation or downloading in the UK, then these are the acts that are alleged against my client, D4. And then he referred to 31, and he put particular weight on, by reason of the acts about which complaint is made, again referring back to those points, herein, on air has unlawfully acquired, used, and or disclosed a trade secret within the meaning of Article 3 of the regulations. And he said, well, within the meaning, that covers Article 3.5, importation. So we should have read that and understood that. So, but in my submission, that's simply not open to him when he has provided particulars, which he carefully didn't show you, as to the acts that were identified, which do not in any sense coincide with the UK, do not identify any online bookmaker launching any of the derivative games in the UK, let alone any party that's encouraged that. But assume against me that that is within that pleading of misuse, that there is to be implied, the broad pleading somehow covers importation or downloading or whatever. The test then, in relation to his amended claim under, because he was already amending to bring under, was that set out in Kawasaki. So turning to the judgment, we can take this, the Kawasaki test. So the judgment behind tab 7, paragraph 16 of the judgment, this is the approach the judge was rightly saying he should apply. So page 72 behind tab 7, the approach to the first requirement, the merits test, summarised by Lord Justice Popplewell and Kawasaki, and then these 3 points. It's not enough that the claim is merely arguable, it must carry some degree of conviction. Where is the conviction that applies to any the direct loss or the importation or downloading he's relying on? The pleading must be coherent, that it is not, insofar as it relates to those points that my learned friend now seeks to smuggle in, and properly particularised, same again. And the pleading must be supported by evidence which establishes a factual basis which meets the merits test, not sufficient simply to plead allegations, in this case unparticularised allegations, which if true would establish a claim, there must be evidential material. And my learned friend fairly accepted there's not a whisper of evidence in relation to the derivative games of any download, the fact they've even been launched in this country. If he'd been running this case below, it wouldn't have passed the Kawasaki merits test and it wouldn't have been open to him. He wasn't running it, and so the judge considered the case he was running, which was all to do with the broad facts with no allegation of any activity within the UK. That brings me on briefly to if it's open to my learned friend to argue that downloading or access to the games from the UK is in some way within his case, then the pleading we would expect to have seen in that would actually specify whether he's talking about an allegation of access to a game that's on a server elsewhere from a party here, or downloading of software which he says may be a good into the UK. It doesn't say that. There's no specificity on that. There's no specificity as to who is responsible for the downloading or access. There's nothing within there that could satisfy the Kawasaki test in respect of the key act that he now says he relies on. And if it were the case that that somehow scraped over the direct damage test, then it would have to be looked in the broad, in the sense of the broad allegation of his wider claim, because his claim is, I think his case is that it's so broad it encompasses this, in which case the rest of that claim, which relates to the access by Mr Veliks in Latvia, the development in Latvia, is all to do with Latvia, and we'd rely on that on the Article 4.3 of Rome 2 escape clause. We say that all, even if there was some technical whiff of direct damage, the escape clause of 4.3 would say this should be dealt with in Latvia. Which brings me on to the question that my learned friend asked, where he says, what damage is there in Latvia? What damage? He posed forensically the question. And that's not the right question. The question is, what direct damage is there? What direct damage? And in Latvia, there may be limited direct damage. There's no direct damage here, but the damage that is suffered as a result of the acts that go on and that happens outside Latvia is precisely the form of indirect consequential loss that my Lady Justice Falk referred to, which is excluded from the consideration of direct damage. So what damage in Latvia? All the direct damage is all that was suffered in Latvia. All that is suffered in the UK is the indirect, is the consequential, is the impermissible for the purposes of considering Rome II and jurisdiction. So his question is a sensible one, just doesn't give the answer that he hoped it would. In response to my Lord Justice Arnold's question about whether there is a point of law, that the judge actually decided the issue of applicable law, it shows the confusion in his approach that he doesn't expressly set it out. But it is, I accept, implicit that he must have come to a view on English law, because that's what we asked him to do when we sent him an email saying you haven't addressed it. But it is so confused that I think it is entirely possible that by the time you get to paragraph 106, he's forgotten the question, which is supported by the fact that when he considers Gateway 21, if he'd already decided and had in his mind that English law applied rather than Latvian law, you wouldn't have to think about direct damage. You just say you pass through point E in Gateway 21, which is if English law applies, then this is the place to hear the case.
Nor would you have to consider is it A or B or C or D?
Well, exactly.
Because it would be A and D.
You'd have had both of them. Even my learned friend, Mr. Silverlever, would have been right in that sense, in his textual analysis. I mean, or more point, his point would have been defeated even if he had been right. Sorry, is the best way of putting it. Those are...
Just on Gateway 21, would you answer the question I asked the same way about whether A and D, whether the governing law and the detriment come to the same thing?
They do come, that they are...
For present purposes.
For present purposes, they come to the same thing. So the criticism I make of the judge in essentially only approaching it under A, it's not one that's material, but it's indicative of a confused approach that is shot through his judgment. So but having approached the Rome II question in terms of indirect harm and considered that then applies, we say it should apply Latvian law, he said English law, but that then, it means you pass through the gateway in two different ways.
Put it another way, the detriment in paragraph A can't include, you would say, indirect.
Yes, precisely. That's a much more elegant, if I may say, way of putting it. And finally, my learned friend showed you the decisions. He went through the operative parts of the judge's decision, saying that here is the judge finding. In I think it's 108 and 109 that there is 108 that there is damage in the UK as a result even of the indirect, even of the acts of access in Latvia. So he said, and he's right. The judge is making those findings, but we say he's making them on a misconceived basis because he's not considering whether they are in fact direct damage and so relevant. They couldn't be viewed as being direct damage. So it doesn't help my learned friend to say, look, the judge has decided this, when the basis on which he's deciding it is one of the errors of which we complain. If I'm right, then I remain right, and if I'm wrong, well, I'm wrong anyway. And that is just the way the cookie crumbles. Let me check. I haven't addressed, my lords, my lady, you on the interesting point of whether under Article 3.5 that there's a question of law, because in my submission, notwithstanding what my learned friend said, it simply doesn't arise on the pleaded case. So that's unless I can assist you further, those are my submissions.
Thank you all. That's very economical.
Before my lord finishes,
yes.
Can I just tell my lords and my lady, I was right on my recollection. I can't give you each a copy, but we will. In the transcript, the judge was told that DNA equate to the same thing for Gateway 21.
All right.
So we'll make sure.
Thank you for that. Good. All right. Well, we will be reserving our judgments, and I'm sure most people in court will be aware that the practice is that drafts will be circulated in due course to those counsel and solicitors whose details were supplied before the hearing, so that they can draw our attention to any typographical or minor factual errors and hopefully agree a draft order. If you can't agree a draft order, please file brief written submissions and it will be dealt with on paper. And as I'm sure you're all aware, circulation to anyone for purposes identified in the General Counsel for Wales are the responsibility of the solicitors. It should only be for those purposes, and any other publication may be a contempt of court. And then the final version of the judgment will be handed down digitally, and no further attendance required. Thank you all again.
All rise, table.